Today on Bench Briefs, we're looking at a landmark case that tests the balance between public safety and fundamental freedoms in Canada. Canada Attorney General v. Canadian Civil Liberties Association, decided by the Federal Court of Appeal in 2026, tackles some of the most pressing constitutional questions during times of crisis. Here's what happened. In response to a national emergency, the federal government enacted a set of emergency measures. These measures restricted certain fundamental freedoms, such as freedom of expression, freedom of assembly, and mobility rights. The government argued these restrictions were necessary to manage the crisis effectively and protect public safety. But the Canadian Civil Liberties Association, or CCLA, stepped in and challenged these emergency orders. They argued that the government's actions infringed on rights guaranteed by the Canadian Charter of Rights and Freedoms. The CCLA applied for judicial review, seeking an order known as certiorari to quash the emergency orders entirely. Before the court could even dive into the substance of the charter rights claims, it had to tackle some important procedural questions. First, did the CCLA have the legal standing to bring this challenge? In other words, did the CCLA have the right to ask the court to review and potentially cancel these government orders? Standing rules are designed to ensure that courts hear cases brought by parties with a genuine interest or stake in the matter. Second, the court had to decide whether it had jurisdiction to conduct a judicial review of emergency orders through certiorari. Certiorari is a powerful judicial tool that allows courts to quash decisions or actions made by government authorities if they are found to be unlawful. But emergency measures often come with their own legal frameworks, so it wasn't obvious if certiorari was the right path here. Finally, once those procedural hurdles were addressed, the court turned to the core constitutional questions. Did the emergency measures violate fundamental freedoms protected by the Charter? If so, could those violations be justified under Section 1 of the Charter, which allows reasonable limits on rights that can be demonstrably justified in a free and democratic society? The Federal Court of Appeal ultimately held that the CCLA did have standing. As an organization dedicated to protecting civil liberties and with a history of challenging government actions affecting fundamental rights, the CCLA's role was recognized as important in ensuring government accountability. The court also confirmed that it had jurisdiction to review the emergency orders by certiorari. This was a significant affirmation that even during times of crisis, government actions are subject to legal scrutiny and must comply with the law. On the substantive charter issues, the court found that some of the emergency measures did indeed infringe on protected freedoms. However, the court also acknowledged the extraordinary context of a national crisis and applied a careful balancing test under Section 1. Some restrictions were upheld as reasonable and necessary, while others were struck down for being overly broad or disproportionate. Why does this case matter? It's a vivid reminder that the rule of law doesn't take a back seat during emergencies. Governments have the power and the responsibility to protect public safety, but that power is not unlimited. The courts serve as a crucial check, ensuring that even in difficult times, fundamental rights are respected and any limitations are justified. This case also clarifies important procedural questions about who can challenge government actions and how courts can intervene. Recognizing the standing of organizations like the CCLA helps ensure that government decisions do not go unchecked, especially when they impact fundamental freedoms. For Canadians, the decision sends a clear message. Civil liberties are a cornerstone of democracy, and protecting them requires vigilance, especially when the stakes are highest. It encourages a thoughtful, principled approach to crisis management, one that respects both public safety and constitutional rights. Thanks for listening to this episode of Bench Briefs. Join us next time as we explore more cases that shape Canadian law and impact everyday life. Until then, take care and stay informed.